The future of 6 families living in the Searle Street cottages in District 6 remains uncertain for now. The families have filed an application in the Western Cape High Court to compel the state to expropriate their homes to avoid their eviction and displacement. We speak now to one of the lawyers that is involved in their case, Jonty Cogger, Ndifuna Ukwazi attorney. Jonty, thank you very much for your time this afternoon. So as we understand it, the families that survived the forced removals during the apartheid era have been living in the cottages for 3 generations since the 1920s. Let's start with a bit of background.
Yes. First of all, thank you for having me. I think these are one of those cases where it really touches your heart. 3 generations of families living in District 6 survived the Group Areas Act forced removals due to a technicality because they were living on church land, and the church made successful representations for their forced removal to be excluded from the Group Areas Act, only to find that post-apartheid, where we're supposed to have freedom, they now are subject to an eviction because the church then sold the land to a private individual who now seeks to develop the land. And so it's quite ironic, this situation, seeing as though District 6 is one of the most symbolic forms of just forced removal, yet now, post-apartheid, they could suffer the same fate.
What was the conversation in the sale of this piece of land between the church and the new developers? Were they made aware that there are families who have claim over the land?
I wasn't involved at the time of the sale, but I'm aware, because of the proceedings on record, that the families were desperate to buy the land, their homes from the church. In fact, made various offers, yet the church went to the highest bidder and sold them to an individual who doesn't reside in District 6.
An entire church. What is it that you are arguing?
Ndifuna Ukwazi is going to be entering as amicus in this case, which means that they will be friends of the court. And our job is to contextualize the issues. And one of the big issues is the continuation of spatial apartheid in Cape Town. These families have resisted forced removals, yet now are being offered alternative accommodation, emergency accommodation, by the city of Cape Town, 30 kilometers away. And that act in itself is a replaying of the apartheid playbook, where black colored families living in close proximity to the city were removed. The only thing is that it's not happening through laws or policies, but it's happening through market needs. And so this is privatized apartheid being reenacted. And what we're arguing is that we need creative solutions to stop the tide of this legacy of apartheid from continuing. And if there is such an example of a District 6 family who's lived there for 100 years, should be the type of case that wakes people up to the realities of what's happening in Cape Town.
How to address that, right? Because this has been going on for years. Like you mentioned, it has now morphed itself to a more financial sense. And so what else do we reintroduce?
I must be honest, it's quite a desperate situation, and it's not just happening to these families. As an attorney, I represent numerous families who are evicted from areas such as Woodstock and Salt River Observatory in Mowbray, and they're offered peripheral emergency accommodation, which is far away from their homes, which dislocates them from economic opportunities. And I must be honest, it's dire. The courts have condoned these types of far-flung peripheral locations. They don't seem to see anything wrong with these emergency camps. Yet there's nothing different between the way that the apartheid and colonial authorities were dealing with poor black colored households during that time and how the post-apartheid government is dealing with them now. So at some point, something's got to give. We can't replay the sins of their past.
Thank you very much for your time this afternoon. Jonty Cogger is an attorney with Ndifuna Ukwazi.